So thanks for joining us at East State Academy. We're going to take us through. Let me just actually move this over here. We're going to take us through sort of the simple gifts, what clients think are simple gifts, but they're really not. And they each, even though they seem simple to the client, they each have a whole bunch of issues that we as advisors should canvass with them that they probably didn't think of, and that's why they're coming to us. And so the idea is we're dealing with my subtitle is "What Could Possibly Go Wrong with a Simple Gift?" So we're going to find out, is I guess the idea. So the first simple gift that clients think about is I want to give a specific amount of money. What the legal term, of course, is legacy. And it's a specific amount of money. We're going to use that. Cash legacies is the example of a very simple gift. And the gift is I want to give, $50,000 to Susan. So we get those instructions from our client, and now we have to remember, I say about 8 issues that we should think about and canvass with the client. So, so the first one, and this is not necessarily in any particular order, but the first question is, we're saying $50,000 today, and that's what the will is going to say. Does the client want that amount to be indexed? So do they want it to go up each year in accordance with some sort of indexing scale? We typically use the consumer price index year over year. And so if in 2020, we leave $50,000 to Sue, and the client dies in 2050, then we would take the 30 years of and multiply that $50,000 by the increase each year. And so they're going to end up with more than $50,000. And that's one way to sort of take into account future growth. So that's the first thing. Second thing is, and I'm pleased to answer any questions at the end. If you want to just send it through the chat, I'm happy to address any of these, but we'll leave it to the end if that's okay. The next thing is currency. So we typically assume it's going to be in Canadian currency, but that's just something to double check, especially if you've got a beneficiary who's a foreign beneficiary. And if they're in the US, it could end up being much less if it's being converted. If it's in Canadian dollars, then an equivalent amount in the US dollars. The next one is really, I think, the most important for us to think about, and that's the question of abatement and priority. So if it's a small amount, then that's not a big issue. If the estate has $1 million and you're giving $10,000 to somebody, then the risk that there's not enough money to pay that legacy is slim. The one catch is if everything is joint. For example, they make a gift in the surviving spouse scenario, so where one of them dies and they're making a legacy to a third party, and everything is joint. Well, then there's no money at all in the estate to make that legacy payment. So that's something to canvass and to show, and I can show sort of how we can avoid that or recognize that problem. Then the next thing is where you leave so much in legacies that not only is there nothing in the residue, but there's not enough money to cover all of the legacies in full. So I give $100,000 to this person and $1 million to that person and $2 million to that person. And sure enough, there's not enough money to cover all of those. And that's the example of abatement. So if you say nothing about that, if you don't canvass that with the client, for example, or if the client just says, no, I don't want you to worry about it, then what's going to happen is they're going to abate pro rata, basically. So you add up the total amount of the legacies and then take each legacy as a percentage of the total, and that's the percentage of the amount that's left to distribute among the legacies. But you are entitled, and in fact, as a client, you're entitled, and as an advisor, I think we should raise this with clients that, what happens if there's not enough money? So do you want certain legacies to be paid in full before other legacies? And so if that is something that, is important, if there is the risk of an abatement. So if there's not enough money, often people say, look, I want my kids to get the first $1 million, and then I'll be happy with the other people getting their amounts as long as my kids get the first $1 million. So you can do that using legacies and priorities. You say first the children get paid in full, and if there's not enough to pay all of them and pay that full amount, then they get whatever there is. It's not pro rata. And then sure, once they get all of their money, now we can go to the next level and the next level and the next level. So that's the third option, or the third issue. Fourth issue, do we want that amount? Is there some reason, and this is a bigger issue with bequests and devises, but is there some sort of a requirement to count that against their share? Likely with legacies, that's not an issue. But in some cases, depending on the drafting and the wishes of the client, that might be. Next issue, is the legatee a minor or an incapable person, right? So how many of us have heard, yeah, I want to give $50,000 to each of my grandchildren or nieces, nephews, or whatever. We obviously have to remember, or we have to think through, how old are these people and do we need a trust for them? On the issue of minors, anything less than $10,000 to a minor can be paid to the parent or guardian without a trust. So you might keep that in mind under Ontario law. Next issue, timing and interest. So the common law is that legacies, a cash amount, have to be paid within 1 year of the death. And it is not dependent on extraneous factors like there was a will challenge that delayed us, or we didn't have the money to pay it, or whatever. If it can't be paid within a year, then legacies attract interest. And they attract interest at a fairly high rate, and at 5%, basically. And so, and there's some new case law from the Court of Appeal about this. So if that's an issue that you want to look at, there is a relatively new case, and I'll try to find that for you and circulate it, or at least the name of it. So if that is not something that you want, or the client wants to do, so if they say, look, I don't expect these legacies to be paid because I'm going to have to sell the house in order to make those payments, and we might not be able to do that because there's a trust or whatever else, then putting in something about how, regardless of how long it takes to pay the legacy, no interest shall accrue, or something like that, or address that with the client. 7, are there any conditions that are made to this gift? In other words, aside from being alive, which is a condition implicit in every gift, at least in these kinds of gifts, is there some other condition that you're going to make? And as I always say, a condition might, if it's a condition that has to be met right at the date of death. So in other words, they have to be, I don't know, drug-free or something. You could put those conditions in. They have to be very carefully drafted. And you have to also provide for what happens if those conditions aren't met. I typically think of conditions more like a trust. For example, I want them to get the money, but not till they're 30. That indicates a trust rather than a condition. And then the last thing is, what happens if whatever condition isn't, whether they're not alive, if that's the only condition, where does it go? Does it just fall into the residue, which is the default rule, that if a legacy lapses because the beneficiary is not alive, it's going to fall into the residue of the estate. But I would typically want to say something about that legacy, that gift over, and say, maybe specifically say it falls into the residue. So those are so here's a really simple set of instructions. I want to leave $50,000 to Sue, and we have 8 issues to go over with the client. And so that's the first example. That's the simplest of the simple gifts. The next one that I want to deal with is bequests and devises and designations. So the client wants to give a specific asset to a specific person, okay, or people. And I always start, whenever a client says to me, I've worked out the plan, here's what I want. As soon as they say that, I know, oh, I'm in for some trouble. Because they're going to say, well, I want this house to go to that person. I want that house to go to this person. And we're going to give them the bank account. And then I'm going to put his name on a GIC. And then I'm going to make them a designated beneficiary of the RSP. And I've worked it all out. And that's what I want. And I would immediately, in every case, say, is there a really good reason that you want to give this specific asset away to a specific person? Because the biggest issue is that we have no idea what the value of that gift will be. We are acting as or the client is, and we are acting as fortune tellers. I want them to get this GIC. Well, that might be an easier one. I want them to get this house. How much is the house going to be worth? And is it going to be completely out of whack with what their intention was? So, the two sub questions is, why not include this as part of the residue? And second of all, is there a way to do it so that the client the beneficiary gets that asset, but it's equalized with the other beneficiaries as part of the residue? Okay. So those are the fundamental questions. Let's dig deeper now. So the first set of gifts are bequests. Bequests are gifts of non-land, so non-real estate, so personal property, not just personal effects, but personality in the old language. So some of these are shared between devises of land and bequests of personal property, but let's go over them. So the idea that we can identify that gift, if the client is saying, well, I want to give my ring to John, can I identify which ring it is? And maybe I want to define that in the definition section or somewhere that identifies that properly. That's especially important, if it's bank accounts, if it's GICs, if it's any kind of asset, you want to make sure you can identify it, and that consider using a definition if you're going to reuse that term. The next one, this is akin to the cash legacy issue of abatement. And this is ademption. So the law about gifts of personal effects, or not personal effects, personality, is that if we can't locate that asset at the date of death, or it doesn't exist, or the deceased didn't own it, then that gift lapses and they get nothing. The beneficiary gets nothing. That's the concept of ademption. So if I give away, my bank account to John and I don't own that bank account at death, John gets nothing from that gift. So that's a huge issue. When you try to plan, again, this is fortune telling. This is trying to predict, am I ever going to sell that property? Am I ever going to give it away before I die? Right? So I'm not a big fan of being a fortune teller because that's how we get in trouble. So that's just something to consider. And this is an example of how hard being a fortune teller is. So you might want to think about what happens if that asset is converted into a different form. That bank account goes to a new bank account. What about, a substitutional property? So if I want to give you my GIC, but if it's transferred into another GIC, or there's a GIC that's bought in replacement for that, do you get that? Or do I give you an equivalent cash if that asset is gone? I give you my piano, but if my piano's not there, you get $1,000. Okay. Now, the client might say, like, if I don't own it, I don't want them to get it, and that's fine. No problem. And then you have in your notes, or you've documented the conversation that's been canvassed, and then you're clear. Because you can bet if that asset doesn't exist, that the beneficiary of that bequest is going to say, oh, the deceased wanted me to get the replacement property. So then you're into a situation of problem. The value of the date of death is the problem with any kind of specific gift, is that the value is going to be most likely different than it was when you made the will. And that's not a question of law. That's more just a question of intention. And are you okay with that? And so I would just simply say that to the client. Are you okay if this property that you think is worth, today is worth $100 is going to be worth $10,000 when you die? Because that's what they're getting. For personal effects, there's the cost of delivery. Who's to bear that? If you're shipping a piano across to a beneficiary in the States, who should pay for that? Should the estate pay for that, or should the beneficiary pay for that? I'm going to address income tax and probate tax with devises. Deduction from beneficiary share. I'll also deal with that in the devise section. And then we have the three other issues that we had with cash legacies. One is the beneficiary minor and incapable, in which case, what happens to that asset? Do we hold it for them? Can we get rid of it? This is especially relevant for minors who are going to receive personal effects. You may want to give some sort of discretion that allows the trustee to store it or hold it for them or even deliver it to them before they're 18. And then are there any conditions to the gift? And what are the gift overs? So we only had 10 items on that list. So that's for a simple, I want to give my piano to someone. There's 10 issues to consider. The last simple gift is the one that's most fraught and often a common idea from clients, especially if they have real estate and they have more than one sometimes, and then pieces of real estate, and they're going to divvy them up. They're going to give one to one person or one to the other. And they thought it all out, and that's what they want to do. So let's take that scenario. Well, we talked about proper description and a title search. Anytime, my general rule of thumb is if I'm devising real property, I want to pull the pin for two reasons. One, I want to make sure I can describe it perfectly. And the other reason is they may not own it, in which case we've got other issues. There's a famous case where the deceased didn't in fact own property that he tried to devise. In fact, it was owned by a corporation. And so there were problems with that. So what associated assets are there? This is especially relevant for a condo. Parking spaces, lockers. Are the contents to go to that with that asset? Are vehicles that aren't contents supposed to go with those assets? Real property can often have associated debts. There might be a mortgage on that property. Who's to bear that mortgage, right? Does the beneficiary get it subject to the mortgage and have to take that over? Or does the estate discharge that mortgage? And the general default position is that the mortgage goes with the land and the beneficiary has to assume it. But that is, an issue to canvass with the client. That should value at the date of not death, but death. So we'll make sure we fix that. But obviously the value, this is the big issue with real estate, it goes up or goes down. And if clients, because they're just thinking, okay, today they're pretty much close. I'll give this asset to that person, that asset to the other person. That's a bad idea. And again, go back to that fundamental question, is that you've got to convince me that there's a really, really, really good reason to do this. I'm adding 2 extra reallys in there. Ademption, substitutional property. We talked about, same issue with a home. Is it this home, or what happens if you take that, you sell that home and you buy another home? Does that go with it? Let's talk about income tax and probate tax. Big issues for many assets. Many assets have an accrued capital gain embedded in them that will be triggered on death, right? We're familiar with the fact that on death, there's a deemed disposition of the value of property and a triggering of any accrued capital gains. So take the home, let's say it's a rental property. It's gone up from the date of purchase from $1,000 to $1 million. Then this beneficiary is getting that home which is worth $1 million. Well, on death, that's going to trigger a capital gain of $999,000, of which about a quarter of it is tax. So $250,000 of tax. And guess what? The residuary beneficiaries have to pay that unless we've dealt with it specifically. So clients don't even think about that. That is where can we get in the most trouble? Right there, right there. So now, certain properties don't trigger income tax, and if they don't trigger income tax, then that's fine. But they can change their form. So, for example, if the client's saying, well, I'm leaving my home and it's my principal residence, well, it might not be their principal residence when they die. So it's better to be safe than sorry. If the idea is that the estate should be relieved of any income tax with respect to this asset, then build that in. And if the income tax is zero, God bless, that's good. So fundamental thing to ask yourself every time there's a gift of a specific asset, and this applies and sometimes even more importantly with beneficiary designations, right? Where there's going to be a tax issue that's going to be borne not by the beneficiary of that asset, but by the residuary beneficiaries, unless we cover it. Probate tax is the same. A house is worth, $3 million. So we've got, significant income tax, $45,000 worth of income of probate tax. I'm sorry. And guess what? The estate's going to pay that. Is that fair? Is that what the client would want? Or should the person getting that home pay the probate tax or equalize that? What about conveyancing costs and legal fees and other expenses relating to the transfer of the home? Now, that might not be as big an issue, but could be land transfer tax, could be other things, although that's not usually an issue. This brings me to 9, which is an issue so when you ask that fundamental question, when you ask that question about, is there, a really good reason to give away this property specifically? And they say, well, John loves that home, I want him to have it. So then I ask 2 additional questions. Well, let me ask you something. Do you want to treat your kids equally? Yeah, I do. Okay, well then this isn't the way to do that, because he's going to get the home, but he's also going to get his equal share of the residue unless we do something different. Oh, I didn't think of that. Well, this is how we deal with it. I got an idea. I got a solution for you. I can get him the home and treat everybody the same. I can use a hodgepodge or an option to purchase that says, look, take your third. Let's say there's three beneficiaries. Take your third, and you can use that to buy that property. And now if the person really wants it, they can have it, but they have it as part of their share. And that requires special drafting and things to think about. But, often if that's the intention, I would say something like, my intention is that John be able to take the home as part of his 1/3, part of his residuary share. But then you've got to think about things like, but after tax, et cetera. And I don't want to financially jeopardize. And I think I'll show you guys some drafting around that. If not today, then next week, about how to draft around these issues. Because these are very simple, but very dangerous issues. So that goes back to that fundamental question. Is there a really good reason to do it? And if the really good reason is they really like it, but I still want to treat my kids equally, then a devise without any deduction is not the right way. And that's how you get in trouble. If it's being left to more than one person, then you've got co-ownership issues. And just something to say to the client, again, there's not necessarily drafting. There could be drafting, but it's more a question of, understand, like, do these 2 people that you're giving this property to get along? And how are they going to pay the expense? Like, this is a cottage issue. Like, okay, what's going to happen? Well, I'll be gone, so they'll work it out. And if they can't work it out, well, then they've got a partition and sale application if it hasn't been thought of in a different way. Environmental issues, just something to keep on your list of issues to check. If the client's got, a business property that's on an old gas station or something, if you're giving that property to somebody, who's going to bear the cost of cleaning it up? Because you can imagine the cost of that, and what is the obligation of the estate to clean it up before transferring it to the beneficiary, right? So those are issues. Again, minors, incapable people, right? Very difficult with land, especially difficult for minors or incapable people to own because it's very difficult for them to sell or mortgage or do anything else. And then conditions and gift overs. So that is That one had 14. The one before it had 10, and the one before it had 8. So real simple. I got a real simple will for you. You know, this is why we still need lawyers, I think. You know, if you're one of the people like me that is concerned that we are not explaining to clients why lawyers are important in this field, and why financial advisors and experts in this field are not required, it's because you know, we're not showing people that really there's a lot of issues, even for the simplest kind of thing, because we don't want to be fortune tellers. So I want to address a couple of questions. So if people have questions, feel free to deal that. A question about title searching for devises. If I am doing a devise of property, then I am going to do a title search. I don't do a title search in every case just because the clients have property. But if I don't do a title search for a devise and it turns out that the address isn't quite right, or those kinds of things, I mean, there's saving provisions, but I'd do a title search for sure if you're giving away specific property. Often they don't have the PIN, but it's so easy now to sort of just go online and type in their name and find the property. So that shouldn't be a big property. You know, the issue is what property. James raises the issue about, you know, principal residence exemption, and clients banking that this property is going to be the principal residence, you know, going to have the principal residence exemption, no tax. That's why I said my point was really better to be safe than sorry. You say if it does attract tax, who do you want to bear that? Yeah, so how do you deal with a situation where you want the beneficiary of a registered plan to pay the tax? Well, it's easier if they're also a residuary beneficiary. So yes, I would, I would again canvass very seriously why you're doing that. There has to be a really good reason to do that. But yes, if there is tax, then you probably want to make that gift of whether it's residue or such other property that they're getting under the will, some sort of equalization for the tax, so that if they don't pay it, it's going to be deducted from their other inheritance. That works fine if they're getting another inheritance. It doesn't work so well if they're not getting, if they're only getting the RSP. Make sure it's worth it to avoid that probate tax, to create that huge issue. Right. And yeah, I mean, does the beneficiary want that want that asset? Obviously, that's a great question. Clients often think that their kids or someone really, 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 really wants that cottage or asset or whatever it happens to be, and in fact, the kid doesn't want it. But of course, they could always sell it. That's the thing about, we're right now just talking about specific, simple gifts. You get this, right? That's what we're talking about. And even these simple gifts cause problems. So it is just turned 1 o'clock as I finish my comments. I just wanted to see if anybody had any other questions or issues that they wanted to raise, and I'd be happy to address them and maybe put them in the chat. And what we'll do next week is we're going to talk about some of the drafting issues involved in these simple gifts, as well as how to report them out as well. So that's what I'm going to take on tomorrow, or sorry, next week. And I hope that you found this useful. And we will be back next Thursday, but I'm going to stick around, and you can feel free to ask questions on this topic or anything else. So